Um, welcome everybody to the City of Richmond Rent Program, Rights and Responsibilities for Richmond Landlords and Tenants. My name is Palomar Sanchez, and I am a staff attorney for the Richmond Rent Program. The date is August 26, 2022. All right, so here are the topics that we're going to be covering. First, the purpose of the rent ordinance, properties covered under the ordinance, enrollment, registration, and the residential rental housing fee, the just cause for eviction and eviction noticing requirements section, the maximum allowable rent, otherwise known as the MAR, and annual general adjustments or AGAs, the rent adjustment petitions, and overview of important California law. Okay. Okay, so the purpose of the Richmond Rent Ordinance, excuse me, the purpose of the Richmond Fair Rent, Just Cause for Eviction, and Homeowner Protection Ordinance, also known as the Rent Ordinance, is to promote neighborhood and community stability, healthy housing, and affordability for renters in the city of Richmond by controlling excessive rent increases and arbitrary evictions to the greatest extent allowable under California law, while ensuring landlords a fair return. So as you can see, the Richmond Rent Ordinance is broken up into essentially two pillars. One is rent control, and the other is just cause for eviction protection. So let's go over rent control. Rents are regulated. I'm sorry, hold on 1 second. The maximum allowable rent is calculated by taking the base rent and the annual general adjustments, otherwise known as cost of living increases, and any allowable individual rent adjustments that are ordered by a hearing examiner. So again, we have essentially three basic components to the rent control aspect. One is the base rent, which is the rent in effect as of July 21st, 2015, or the first rent charge for the tenant if they moved in after that date. Then there's the annual general adjustment, which is 100% of the consumer price index in the Bay Area, otherwise known as the inflation rate. And then there's the petition process, which is a mechanism to increase or decrease the MAR based on reasons permitted by the rent ordinance. Now, the just cause for eviction protections aspect. So a landlord needs to have one of the 8 just causes to terminate a tenancy. The first one is failure to pay rent. Second is breach of lease. Third is nuisance. Fourth is failure to give access when the landlord has a lawful right to do so. Fifth is that temporarily vacate in order to undertake substantial repairs. Again, it's a temporary eviction. Owner move-in or owner relative move-in eviction. Withdrawal from the rental market, otherwise known as the Ellis Act, or a temporary tenancy, which is specific to a single family home, and the landlord wants to rent out the unit for up to 1 year. So which properties are covered by the rent ordinance? There are fully covered, which means there's rent control and just cause for eviction protection. And that includes most multi-unit properties built on or before February 1st, 1995. Then there's partially covered units, which means that only the just cause for eviction protection aspect would apply, but there is no rent control. So these kinds of units are subsidized units, including Section 8 tenancies, properties with one dwelling unit on one parcel, condominiums, and new construction, which is anything built or constructed with a certificate of occupancy after February 1st, 1995. And then there's fully exempt, where there's no rent control and no just cause for eviction protection. Some examples of this would be if the landlord and the tenant share a kitchen and or a bath, single family homes where a permitted ADU is added and the main house is owner occupied, and then retirement homes. This is just a chart to help people understand if your property has an accessory dwelling unit, whether that's 1 or 2 or more, can change the outlook. However, this is going to give you essentially a guide as to how that would work. And so on the left column, you see the larger house, and then on the right, there's like a smaller box. The smaller box represents the ADU. And then a solid line would mean that it's permitted, and a dotted line means it's unpermitted. And then it just depends on, what those circumstances are. And then on the right of the arrow, you'll see where those units would fall under the rent ordinance. So next is compliance with enrollment, registration, and fee payment requirements. There's essentially 2 aspects to this for landlords: enrollment and tenancy registration, and then the rental housing fee. So property enrollment requirements. This is just a sample of the top of the page of the property enrollment form we currently use. It's required for all landlords of rental units covered by the rental ordinance, and that form can be found at the website at the bottom of the screen. Tenancy registration is only required for fully covered units, so those that fall under rent control. So this is, again, a landlord's form where they must file for each existing tenancy. And again, this is just a screenshot of the top of the page, but for every fully rent controlled unit, this form needs to be provided when the tenancy begins. And when I say provide it to the rent program, so you can send it to us, you can email it, you can fax it, any way you want. So the importance of enrollment and tenancy registration. So first of all, it increases compliance. So submitting information about rent and housing services improves compliance with the rent ordinance by making lawful rent levels transparent to both landlord and tenant. Registration is required for each new tenancy or upon turnover of all original occupants. It supports the rent adjustment petition process. Excuse me. Tenancy registration provides the hearing examiner with data on lawful maximum allowable rent levels for units under construction for rent adjustments, provides base year rent data for rent controlled units. It bolsters outreach opportunities. In the near future, tenants and landlords will receive an annual notice of maximum allowable rent and a guide to rent control in Richmond, informing them of vital information about their rights and responsibilities. It improves the fee study and billing accuracy. So enrollment improves the accuracy of the rent program's inventory of rental units and its annual fee study. Landlords are required to enroll rental units and update the status of rental properties. For example, if a unit is now owner occupied, or if a Section 8 tenant moves out and a rent controlled tenant moves in, or just a regular tenant moves in. Also, compliance is required for rent increases or eviction. An important reason for enrolling and registering your tenancies and paying the fee is that failure to substantially comply with the applicable sections of the rent ordinance may prevent the landlord from raising rent, e.g. taking AGAs, and may be an affirmative defense to an eviction lawsuit. So this is the residential rental housing fee. So the rent ordinance requires that the City Council to adopt a residential rental housing fee following the recommendation from the Rent Board. So as you can see, we have listed the fees for every fiscal year since we've been around, which is 2017. And then the current year is at the top. So that's fiscal year 2022, 2023. For fully covered rental units, it's $226 per unit per year. So that's for the entire year, $226. And then it's for partially covered units like single family homes, condominiums, and new construction units, it's only $127 per unit for the year. All right, so now we're talking about compliance with just cause for eviction requirements. So there are essentially 2 categories here. One is the actual just causes for eviction, and the second is eviction noticing requirements. So this is a list of the just causes for eviction, and the section of the Richmond Municipal Code is listed at the top. So residential tenants can only be evicted for one of the following reasons under the just causes under our ordinance. So one is failure to pay rent, after having been served a 3-day notice to pay or quit. 2 is breach of lease, if a tenant continues to violate the lease after being warned in writing to cease the violation. A nuisance, if a tenant continues to cause a nuisance after being warned in writing to cease causing nuisance. And before we go on, some of you may be wondering what a nuisance is. A nuisance is a very general term, but essentially it is where a tenant is committing some type of act which is a unreasonable intrusion into another tenant's quiet enjoyment. So there can be all kinds of things. It could be having loud parties every night. You can have very loud, aggressive dogs. There's various other examples, but essentially it's a very general term where one tenant is causing some type of issue for another tenant or the owner if they're around too. The next one is failure to give access. If a tenant continues to deny a landlord lawful entry per Civil Code 1964 after receiving a written warrant to cease denying the lawful entry. The next one is to temporarily vacate in order to undertake substantial repairs. Again, that's a temporary eviction. You have to let the tenant back in. Owner move-in eviction or owner relative move-in eviction, where the owner or the owner's relative wishes to reside in the property for at least 3 consecutive years. Withdrawal from the rental market, otherwise known as the Ellis Act. And then a temporary tenancy, which again is specific to single-family homes, and you want to rent it out for up to 1 year only. And so the asterisk there for up to the 5th, 6th, and 7th just cause, so that's temporarily vacate in order to undertake substantial repairs, owner move-in, and withdrawal from the rental market. All of those would require a relocation payment under the relocation ordinance established by the Richmond City Council. So the written warning notice requirements under the rent ordinance are as follows. So this must be served prior to a notice of termination of tenancy if the just cause for eviction is breach of lease, nuisance, or failure to give access. The landlord must provide the tenant with a reasonable period of no less than 5 days to correct the violation prior to serving a notice to terminate the tenancy. They must state that the failure to cure may result in an eviction. They must inform the tenant of their right to request a reasonable accommodation. And the notice shall include the contact number of the rent program. It shall include instructions for compliance and shall include information necessary to determine the date, time, place, witnesses present, and other circumstances regarding the alleged violation. We actually have a template for a written warning notice, and it can be found at the website address at the bottom of the screen. So there are some additional noticing rules under one of our rent board regulations. So the landlords must submit a copy of any termination of tenancy notice served on a tenant within 2 business days of serving a tenant, along with a proof of service. Again, it's the termination of tenancy, the notice, not the warning letter that we just described in the previous slide. However, if you issue a warning letter and notice, and then you issue a termination notice, you have to attach the warning notice as well, along with the proof of service. The termination of tenancy notice should be submitted online, and there's the website there to find the portal. For properties with 5 or fewer units, the landlords may submit the notice or notices by mail. The rent program does not accept notices of termination by email. Failure to file the termination of tenancy notice timely may be asserted by the tenant as an affirmative defense in an unlawful detainer proceeding. That's the actual name of an eviction. All right, compliance with the rent control requirements. So this is 4 categories. One is the maximum allowable rent, the MAR, the base rent, the annual general adjustment, and rent increase noticing requirements. The first is the maximum allowable rent. This is the maximum rent that can be charged for a controlled rent unit. The rent increase cannot exceed the maximum allowable rent, but it can be less. Even if the maximum rent is not charged, the maximum allowable rent remains the same until it gets adjusted every year per the AGA. But for the time being, it'll stay the same. The landlord may choose to raise the rent to the maximum in accordance with state law and the rent board banking regulation. So the maximum allowable rent, again, equals the base rent plus any annual adjustments plus any individual rent adjustments that have been approved through the petition process. So what is the AGA and how is it calculated? So the AGA is the annual allowable cost of living increase based on 100% of the consumer price index or inflationary rate for the San Francisco Bay Area, which is calculated by the federal government, specifically the Bureau of Labor Statistics. When can the first AGA be taken after a new tenancy starts? The tenancy must exist for at least one full calendar year prior to the September 1st of the following year to implement that year's AGA. So for example, if a tenancy began in February 2020, the first AGA for that tenancy may be taken on September 1st, 2021, not 2020. When during the year can the AGA be taken? Generally, the current year's AGA can be taken on or after September 1 of each year. Can landlords bank AGA increases? Yes, but there is a limit of 5% of previously deferred AGAs, which can be recovered for each year, plus the current year's AGA. But when increases, but these rent increases may not be applied retroactively. So again, just to make clear, this last year the AGA was 1.6%. If a landlord had previously applied unapplied AGAs, that would be 1.6%, the current AGA, plus 5, so it's 6.6%. However, when the AGA is above 5%, like for the 2022 AGA, landlords may not bank their unapplied AGAs until the AGA returns to a level below 5%. For more information on banking, see Regulation 602. So again, the AGA for 2022, September 1st of this year, is 5.2%. And so on or after that date, landlords will no longer be able to bank any previously unapplied AGAs until that AGA returns to a level at or below 5%. Okay, all right, now it's below 5%, excuse me. So here's a list of all the annual general adjustments. 2016 is 3%, 2017 is 3.4%, 2018 it was 3.6%, 2019 is 3.5%, 2020 was 2.9%, 2021 was 1.6%, and then the current, as of September 1st, the current AGA will be 5.2%. And again, a landlord must give the tenant proper notice of a rent increase per California Civil Code 827. A landlord may increase the rent up to 10% with a 30-day written notice. However, if it goes above that, then it's a 90-day notice. And just to remind you, the percentages that dictates which notice to use, 30 or 90, you look at the previous 12 months. So it's not just that one increase. So if over the past 12 months, the increases have been above 10%, then whatever, of the latter increases that bring it above 10%, that notice would have to be a 90-day notice. For more clarification on that, you can contact us to explain. So what are the requirements for taking an AGA rent increase? So there are essentially two requirements. One is the administrative requirements, and the second is the noticing requirements. So administrative requirements, the landlord must be in compliance with all aspects of the rent ordinance, including property enrollment, tenancy registration, paying the residential housing fee, and properly rolling back rents and refunding any overcharges to the tenant. In terms of noticing the requirements, they must provide the rent program with a copy of the rent increase notice with a proof of service within 10 business days of having served the tenant. Reminder, only properties that are subject to the rent control provisions of the ordinance are required to file rent increase notices with the rent program. When rents can be raised to market. So this is essentially under the Cost of Control Housing Act. And so this is where the landlord can go from a rent control amount to resetting the rent to any level they wish. And then after that, it becomes rent controlled again. But so they can go to market when there's a voluntary vacancy and a new tenancy starts, when all the original occupants or leaseholders vacate and only holdover subtenants remain in the unit, or if the tenant no longer lives in the unit as his or her primary residence, i.e. the leaseholding tenant is subletting or using the unit as a vacation home. Rent adjustment petition. So these are the tenant rent adjustment petitions. So there's a petition for excessive rent due to failure on behalf of the landlord to roll back the rent, or for charging rent above the maximum allowable rent, just a straight overcharge allegation. A petition to reduce the rent due to a decrease in space, services, and or habitability. This is just for, if there's habitability problems in the unit. These two are largely comprised of most of the tenant petitions that we have received. A petition to reduce the rent to a reduction in the number of tenants allowed. So essentially that the landlord said, maybe start off with 4 people, one of them moved out, and the landlord said, I don't want you to get a 4th person. You can actually petition the rent board to reduce your rent by 25% because that's how much of a percentage the amount of people went down by. Important petition facts. First of all, the landlord has the right to object. Most petitions and almost all habitability petitions will result in a hearing conducted by a hearing examiner. Some petitions will be decided administratively if no objection is filed by the other party and the facts of the case are straightforward and not disputed. And 4, either party can appeal the hearing examiner's decision. So these are the landlord rent adjustment petitions. First one is the petition to increase the maximum allowable rent due to an increase in the number of occupants allowed. And that asterisk there at the bottom, it just says the petition for an increase in the number of occupants will not be approved if it concerns additional tenants pursuant to the regulations of the Richmond Rent Ordinance, section 903B2. I think what that is referring to is if there are additional occupants who are, specific types of family members, then the landlord would probably not get an increase. A petition to increase the maximum allowable rent due to an increase in space or services. And a petition to increase the maximum allowable rent due to an increase in net operating and maintenance costs. Also otherwise known as a maintenance of net operating income petition, which is, I think, by far the most common landlord petition. And then finally, a petition to increase the maximum allowable rent due to an increase in security deposit due to the addition of a pet. Important petition facts. Again, the tenant has a right to object to this petition, just the same, though the rest, most petitions, almost all habitability petitions result in a hearing. Some petitions will be decided administratively, and either party can appeal the decision. Okay, so this is just an overview of important California law that is relevant to both landlords and tenants. First of all is the implied warranty of habitability and the implied covenant of quiet enjoyment. The implied warranty of habitability is a legal theory which has been developed and defined through various court cases. The California Supreme Court has expressly held that the implied warranty of habitability exists in all residential rental agreements in California. So there's a court citation there, so you are free to read that case if you desire. This means that if the landlord's duty, and it is the landlord's duty and promise to provide tenants with safe and sanitary housing, as defined in Civil Code 1941.1 and Health and Safety Code 17920.3, in exchange for collecting rent. Now, similarly, Implied in every California residential lease is an implied covenant of quiet enjoyment, guaranteeing that tenants will be able to peacefully enjoy their homes. This is also codified under California Civil Code 1927. This quiet possession includes two requirements. First, the landlord may not take an action that substantially interferes with the tenant's lawful use of their home. Second, the landlord must take action to provide a tenant with the quiet enjoyment or quiet possession of the tenant's home if the landlord is aware that the tenant's lawful use of the property is jeopardized. And I think when I say take action, I think there's a reasonable amount of action. I don't think it means anything specific. It just means they have to do something. But what that means, I think, depends on the situation. So this is Civil Code 1941.1. Like I mentioned before, it's kind of long, but essentially this law is the one that talks about just basic standards for human habitation, effective waterproofing and weather protection, good plumbing facilities, good gas, heating, and electrical systems, has to be free from debris, filth, rubbish, garbage, rodents, and vermin, stuff like that. So just basic. Health and Safety Code 17920.3 goes a little bit more specific, but this law is very long. But it does talk about, lack of a improper kitchen sink, lack of hot and cold running water, dampness of habitable rooms, infestation of insects. So again, visible mold growth, it gives you a bit more specifics on the standards that are required. Just on the other side of the coin, there's also tenant responsibility. So under California Civil Code 1941.2, a tenant must take reasonable care of the rented property in common areas, such as hallways, and common areas, such as hallways. This means that the tenant must keep those areas in good condition. The tenant must also repair all damage that he or she causes or that is caused by the tenant's guests, children, or pets. So 1941.2 requires the tenant do all the following: keep the premises as clean and sanitary as the condition the premises permits, use and operate gas, electrical, and plumbing fixtures properly, dispose of trash and garbage in a clean and sanitary manner, not destroy, damage, or deface the premises or allow anyone else to do so, not remove any part of the structure, dwelling unit, facilities, equipment, or appurtenances or allow anyone else to do so, use the premises as a place to live and use the rooms for their proper purposes. For example, the bedroom must be used as a bedroom and not as a kitchen. Notify the landlord when deadbolt locks and window locks or security devices do not operate properly. That's it. All right, so now we're talking about Civil Code 1950.5, which is the governing law for security deposit. So it gives you a definition of what a security deposit is. So essentially any payment, fee, deposit, or charge imposed at the beginning of tenancy as an advance payment of rent. And so the first month's rent is usually not considered a security deposit, but money paid in excess of the first month's rent, including what's called last month's rent, is considered part of the deposit. How much can a landlord collect for a security deposit? A security deposit may not exceed 2 times the monthly rent for an unfurnished unit or 3 times the monthly rent for a furnished unit. So when can a landlord deduct from the security deposit? So the law specifically says what they can deduct for. It says they can deduct only the amount that is reasonably necessary to cover rent default, repair damages a tenant or tenant's guest cause other than normal wear and tear. 3, do necessary cleaning, defined as the amount of cleaning needed to return the unit to the same level of cleanliness as the beginning of the tenancy. And 4, if allowed by the lease, cover the cost of restoring or replacing personal property, including keys or furniture, excluding ordinary wear and tear. Now, landlords are obligated to offer a walkthrough inspection at the end of the tenancy. So tenants have a right to a walkthrough inspection no earlier than 2 weeks prior to the tenant vacating. The landlord must give 48 hours notice of the inspection unless the tenant waives this requirement in writing. And the purpose of this inspection is to identify needed cleanings for the tenant to perform before moving out, so as to avoid deductions from the security deposit. Immediately after the inspection, the landlord must provide an itemized list of repairs and cleaning that need to be done to avoid authorized deductions. And even if that is done, the landlord may still deduct for cleaning or repairs that were not identified during the inspection because they were concealed by the tenant's belongings, for example. So continued on with the security deposit law, this law says that the deposit, must be returned within 21 days, that's 21 calendar days after the tenant or tenants leave the unit vacant, and they must furnish the tenant with a written statement itemizing the amount of and purpose for any deductions from the deposit, and 2, must return any remaining portion of the deposit. Where several roommates live together and have paid a deposit, the landlord is not required to return the deposit until the unit is returned to the landlord vacant. And unless the tenants all paid the landlord directly individually, I don't think they are required to give each individual tenant that deposit back. Like if they all came together as a group, then by one person, the landlord is simply required to return to that person. There is a requirement to provide an itemized statement, as said before. However, if more than $125 is deducted from the deposit for cleaning and repairs together, the landlord must also attach to the itemized statement copies of documents showing the landlord's charges and costs to clean and repair the unit, like receipts and work orders. A landlord who sells a rental property must either transfer the deposit to the new landlord or return the deposit to the tenant. And then a tenant's recourse if the deposit is not returned within 21 days of vacating, or if they just want to challenge any of the deductions, even if it's after, or the landlord did return within 21 days. It says that the tenant who did not receive the refund and accounting within 21 days or disputes the amount claimed by the landlord may sue the landlord for the disputed amount in small claims court if the amount is less than $10,000 and up to twice the amount of the deposit for bad faith retention of any security, i.e. the unreasonable refusal to return. In court, the landlord has to prove that the amounts retained were reasonable. Civil Code 1954 is about lawful landlord entry. So it says that a landlord may only enter to make necessary or agreed repairs, decorations, alterations, or improvements, supply necessary agreed services, or exhibit the unit to prospective or actual purchasers, mortgagees, tenants, workers, or contractors, or to make an inspection pursuant to section 1950.5, which we just discussed. The landlord must give the tenant written notice to enter at least 24 hours prior to the entry. The landlord does not need to provide written or verbal notice to enter in cases of emergencies such as fire, flooding, etc. The tenant cannot demand that they be there when the landlord enters, although they can be there, but they can't use that as a condition to prevent the landlord from entering. Entry must be during normal business hours, which is generally understood Monday through Friday, 9 to 5, with some flexibility on weekends. The landlord must state the date and time, as well as the purpose of the entry in the written notice. In Richmond, and just so everybody knows, in Richmond, it is a just cause to evict a tenant who denies a landlord lawful entry after the tenant has been warned to cease denying lawful access and then continues to do so after receiving the notice. Civil Code 1946.1 talks about proper notice for certain termination notice. So for most no-fault evictions, landlords must give at least 30 days written notice to terminate a tenancy if the tenancy is less than 1 year. However, under the same code, under the same code, a tenant must give a 30-day written notice to vacate and can give notice on any day of the month once the lease is converted to a month-to-month lease. A landlord can, with limitations, require more than 30 days notice if the tenant is on a fixed-term lease when they're giving notice to vacate, but that requirement has to be in the lease, and it probably can't go more than maybe like 60 days. So if the landlord asks for 90 days notice prior to the tenant leaving, it's probably going to be unenforceable. Under Civil Code 1946.1, a landlord must give at least 60 days written notice to terminate a tenancy if the tenancy has lasted a year or more. Note, any termination notice served in the city of Richmond must cite one of the permitted just causes for eviction, unless the rental unit is fully exempt from the rent ordinance. Civil Code 827 is the law that deals with proper notice for rent increases. So a notice to increase rent by 10% during any 12-month period or less requires a 30-day written notice of rent increase. A notice to increase rent by more than 10% during any 12-month period requires a 90-day written notice of rent increase. This section, the 90-day part, became effective January 1, 2020. As a reminder, if the rental unit is fully subject to the Richmond Rent Ordinance, landlords must submit a copy of the notice of rent increase within 10 days of issuing it to the tenant. Civil Code 1951.2 has to do with lease breaking. So if a tenant breaks a lease, they may be liable for unpaid rent remaining on the lease, but only if the landlord attempts to mitigate the unpaid rent damages by making a reasonable effort to re-rent the unit, and the unit remains without a sitting tenant. In other words, if a tenant breaks a lease, a landlord cannot make the tenant pay for the remaining unpaid rent unless a landlord can show that they made a reasonable effort to re-rent and were still unable to find a replacement or new tenant during that time. However, once a new tenant occupies the unit, the previous tenant's liability for rent is over. And just so you know, landlords are also capable of breaking, or in other words, violating the lease, which again would release the tenant from any further obligations under that contract. Thank you very much. I really do appreciate that you participated, and hopefully you learned some good information in this presentation. As always, we are available for any questions that you may have. You can call the Richmond Rent Program at 510-234-7368. You can email us at rent@ci.richmond.ca.us, or you can request an appointment by visiting our website at www.richmondrent.org. Thank you.